All right, I believe we're ready to get started. First bill we're going to call today is House Bill 242, the State Amusement Ride Safety and Advisory Council Sunset Extension. We got Mr. Verk and Fuginetti. Andrew Fuginetti's no, he's not here. Do we have anybody from Department of Labor? This is not a complex bill, I don't think. Do we have someone from Department of Labor is here ready to testify on this bill? Please, ma'am, you can sit down and state your name.
Yes, sir. Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I appreciate the opportunity to testify on behalf of, in favor of House Bill 242, the Amusement Ride Safety Board Sunset Extension Bill. My name is Vaifki Verk. I am a Commissioner of Labor and Industry. It's a division within the Maryland Department of Labor. Amongst our units is the Safety Inspection Unit. And one of the divisions of the Safety Inspection Unit is the Amusement Ride Inspection Unit, which ensures the safety of all amusement rides throughout the state of Maryland. This bill, members, it consists of a sunset extension of 5 years for the Amusement Ride Safety Board. The board itself is composed of 9 members drawn from ownership, as well as consumers and mechanical engineer. All of whom contribute to the work of the board, which consists primarily of recommending and advising the commissioner with respect to the adoption of regulations to ensure the safety of amusement rides throughout the state. The board has been very active in the last several years. They have considered and recommended approval of safety standards for challenge courses, and most recently for trampoline parks. This is an important board and ensures the safety of Maryland citizens who use our amusement rides in parks and in other in county fairs and in other settings. And we respectfully request approval of this bill.
Thank you. And just for clarity, the extension is for 10 years, correct?
Oh, I apologize. It is for 10 years.
Okay. And I guess this is an ongoing question most of my colleagues have, myself as well. How long has this been in existence?
The board itself, I would have to get back to you about that.
And this is more for the point of we kind of get these every now and then, these extension bills versus, is there any rationale to your knowledge as to why we don't make these permanent?
Not to my knowledge, but I've only been in this job for 8 months at this point, sir.
Well, you did a great job, then thank you. Not trying to trap you into a corner. We'll figure that out. I do think that something we need to look into because it's just becoming redundant to continue to do this on these, unless we feel for some reason that this is going to time itself out. And I don't see amusement parks going away anytime soon, especially with the advent of the new things you just discussed, the rope courses and the trampoline houses. So thank you very much.
Thank you, sir.
Moving on to the next bill, this is House Bill 244, Maryland Occupational Safety and Health Act, Civil Penalties Alterations. Young lady, you're of course, and I'm sorry, how do you pronounce your first name?
So it's Vaifki.
Last name?
Verk.
There we go. Ms. Verk, I believe you're the only person to come to be here testifying in person, so go ahead, ma'am.
Thank you, sir. Chairperson, Vice Chair, members of the committee, I'm glad to be with you to testify in favor of House Bill 244, which is a bill that amends the caps on the maximum penalties that the Maryland Occupational Safety and Health Administration may impose. This bill would align the maximum penalty caps that are can be imposed by Maryland Occupational Safety and Health with those that may be imposed by federal OSHA. As many of you know, Maryland Occupational Safety and Health is a state plan, which means that our inspectors conduct the same work as OSHA inspectors do for both private sector and public sector employers throughout the state of Maryland. And that state plan is approved by federal OSHA. It is operates under the oversight of federal OSHA and needs to be at least as effective as federal OSHA. And the way that federal OSHA has interpreted at least as effective with respect to penalties is that the penalty caps must be the same, and the penalty structure generally must be the same in the state plans as it is in federal OSHA. And that's what this bill would do, sir. I'm happy to answer any questions.
We have one question, Delegate Pippy.
Thank you, Mr. Chairman. So just looking at the fiscal note here, so we're increasing civil penalty for violations from $7,000 to $15,625.
We're increasing the cap, sir. That means that's the maximum amount. We're increasing the maximum amount that can be imposed, but the actual numbers that the amount of the penalty that's imposed in any given case depends on assessment of a number of factors.
Sure. So what's the maximum penalty one could impose today?
It's $7,000.
Okay. And if this passes, what's the maximum penalty they can impose?
It's, as you said, $15,625 is the maximum penalty.
Perfect. Thank you, Mr. Chairman.
Thank you very much.
Sure.
Another question?
Yes.
Delegate Adams.
Thank you, Chair. Commissioner, good to see you. Over here. So the fiscal note also talks about willful violations. So the max or the cap, is that for a willful violation?
No, so there are two types of violations. There's willful and non-willful. And for willful violations, the current amount that can be and must be imposed is $70,000. And the bill would increase that to $156,254. I would note, though, that willful violations, as you might expect, comprise a very, very small portion of most cases overall. I believe it's approximately 1% to 2% of all citations.
Okay, so and that 70,000 going up to 156,000, that's a one-time penalty. We're not talking about
Correct.
daily by way of example. So
Correct.
in other words, what you're saying is most of these violations, you're not doing the cap. You're probably determining the nature, how often it's happened. Is this the first time offense? And
Exactly.
it probably falls well below the cap. Okay.
Exactly, sir. There are a number of factors that are set forth in the law that must be assessed.
And so last question, Chairman. So you're saying this is a compliance bill because you're saying that OSHA, the federal partner, is allowing us to have a state administration of this portion of labor law, but to be in compliance with the federal part, you have to pass this bill in order to have that happen.
That's correct, sir. OSHA raised its own structure in 2015. And we have been noted on our oversight report from OSHA for several years for not having penalties that the maximum penalties and the willful penalties that align with OSHA's penalties. So it has been a problem.
Thank you. When they noted, are they saying that if you don't change this, we're going to take an action, or are they saying in the totality of what you're doing, these are things that you should consider changing?
They're saying that it is an aspect that makes our plan not compliant with the requirement that it be at least as effective as OSHA. That is what they're saying. So
you're saying we're risking the state administering this plan because of things like this?
Yes, and there's also federal funding. MOSH, our Occupational Safety and Health Program, is 50% federal funded. And that is obviously at risk too if we are non-compliant with the requirement that we be at least as effective as OSHA.
Thank you.
Clarify a couple things. If we don't do this, do we lose federal funding? Federal.
I can't speak for OSHA, sir, but noting that it has been on our report, our oversight report for several years now, I respectfully request that we not take that risk, sir. I do know that they have at least with respect to one state plan, and I don't know if this was the issue, but they have begun proceedings against one state plan for not being compliant with the requirement that it be at least as effective as OSHA.
But we don't know that there's a risk in not doing it.
There is a risk in not doing that. We just don't,
What-
we can't quantify it because, we've never risked it before, sir.
So
And-
we
and
haven't, we don't have a problem yet. You're saying we could.
I'm saying we have a problem because the federal government has said we have a problem in our report. Yes,
But we haven't done it since 2015. So
Right.
that's why I'm asking, I'm trying to get to that. I'm asking her. But thank you. I'm echoed. That's my point. The other question I have, how many maximum penalties have we given out in the last year? Do you know?
that I do not know, but I could certainly find that out and,
Okay.
and get
Okay.
that information to you, sir.
Thank you.
Thank you.
Sorry, Chair. Okay, so Steve, I'm sorry about that. Could you produce that report that's driving this bill? In other words,
Yes.
you're getting something from the federal government saying this. Could I see that?
Yes.
Or could the committee see that?
Yes, I believe it's also available on OSHA's website. I am happy, however, to provide the committee with copies of the report, and I believe it's not just been one, but more than one.
Thank you, ma'am. Could you briefly, because there seems to be a little discussion about this, I thought it was provide a little more clarity. What is the importance of aligning ourselves with our federal partners?
Well, thank you for that question. I mean, there are several reasons why we need to be aligned with OSHA. As a practical matter, state plans operate under OSHA oversight. They receive federal funds pursuant to OSHA oversight. And in order to maintain that funding and in order to maintain the level of independence that we have with a state plan, which allows us to address health and safety issues specific to the state of Maryland differently than all the rest of the country does it, in order to maintain that level of autonomy, we have to be at least as effective as OSHA. And this penalty structure is one element that OSHA looks at in determining whether we are at least as effective as OSHA. Does that help to answer your question, sir?
Thank you. Yeah, it was more for the body, but thank you very much. And I appreciate it.
Thank you.
Looks like we have no more questions. I think we can move on to our last bill, which is House Bill 136. Thank you very much.
Thank you.
And wait, no, you don't have we'll let you present and we'll call the panel. There you go.
Of course.
You're fine.
Thank you. I appreciate the opportunity to testify on behalf of the Department of Labor in favor of House Bill 136. This bill, members of the committee, establishes wraparound protection for employees who exercise their rights under any of Maryland's wage laws. And it provides an administrative process for receiving and resolving complaints of retaliation under those laws. And that process that is incorporated in this bill is the same process that the General Assembly approved for receiving and resolving complaints of retaliation under the Family Act that was passed just last year. As some of you may know, we have a number of robust labor standards in the state of Maryland, including protections against child labor, including protections under the Equal Pay Act, under the Wage and Hour and the Wage Payment and Collection laws, under the Workplace Fraud Law, and of course, for our state-funded projects under Prevailing Wage and Living Wage. But each of those laws has different, not just different substantive protections, but different protections for workers who try to exercise their rights under those laws. Some of them have no protection at all. Living Wage, for instance, has no protection. Some of them have protection for retaliation, but only in the form of a criminal prosecution. That's the Wage and Hour law. So there's a whole patchwork of anti-retaliation measures that have been passed. And again, we don't seek to disturb or change the protections that already exist, but what we believe is sorely needed is a wraparound protection, again, for employees who exercise their rights under any of our wage laws and who experience an adverse action because of that. This bill provides that wraparound protection, and it provides a process. That process that it provides is an administrative process in the initial instance. Complaints may be filed with the Commissioner, the Division of Labor and Industry, at my office. We are bound to investigate and make a merit determination. That simple administrative process will also, again, simplify exercise of these rights for individuals and simplify the process of resolving these complaints. I'm happy to answer any questions about the bill. Thank you for your attention.
Briefly, ma'am, you keep utilizing the term wraparound. Could you please elaborate on that?
Of course. As noted, each one of our existing laws, those that do have protection against retaliation have different protections against retaliation and different methods by which workers may exercise those rights and different remedies in some cases that they may seek. What I mean by wraparound is that despite all of those internal differences between the laws, this is a single process that a worker may use. It's essentially like a one-stop process. And it is one set of triggers for all of the laws, one process for all of the laws, and one set of remedial measures for those laws. Again, we do not intend to displace what is already there, hence the term wrap around. This is a layer on top of what exists already.
And when you say triggers, you're talking about triggers as far as identifying possible retaliation.
Yes, and protected activity in particular.
Delegate Pippy.
Thank you, Mr. Chairman. Are there any protections in this bill for a private employer who, let's say, has an employee that has made several false and frivolous complaints, and at that point, the employer wants to get rid of the employee? So is there any protections for the employer in that scenario? So look, no one's arguing if you have a legitimate claim, and I think that's the intent of the bill. But in a reverse scenario in which you have an employee, private company, who's made several repeated false and frivolous complaints against the employer, citing one of these sections in Section A, Subtitle 3 or Subtitle 4 or Subtitle 9. Again, all false, all frivolous. What sort of remedy does the employer have?
Thank you for that question. If the employee is an at-will employee, and if the complaints are frivolous, there is nothing in this law, nor as I understand it in any other law, that would prevent an employer from firing somebody under those circumstances. This bill doesn't require just cause. This bill requires protection for workers who are actually retaliated against and experience adverse action for exercising their rights. I think the issue you raise is a somewhat separate issue. The employer is empowered to take whatever action it may legally take. This bill does not restrict that action in any way.
So the only issue I have with that, and I appreciate that, is I can read, right? So page 2, it says an employer may not discharge, demote, discriminate against, take other adverse action, or threaten to take adverse action against an employee because it says line 11 makes a complaint or communicates an intent to make a complaint. So that's my concern.
Of
right?
course.
Because it doesn't say frivolous complaint or false complaint. It just says complaint. So.
Right. But I think part of it is that there has to be a determination, right? The person has to be able to exercise their rights. If the employer disagrees, there's a process for that, right? And if the employee makes a complaint and that complaint is determined to be frivolous or unwarranted, and the process has played out to that point, and I don't know that the employer, if the employer were then to fire somebody for repeated complaints, the problem here, I think, is that there's a presumption of frivolousness that you're suggesting might be in the bill. And that's not what the intent is. The intent is to protect employees who wish to complain about their rights. I would say employers are not empowered to take action against employees, even if they believe that the complaint is frivolous, simply for filing a complaint. Again,
Ma'am, I think the question is more centered around the language that he just used, which was that it doesn't say that there was ever a finding, meaning his issue, and again, I don't want to speak out of turn, is that just filing a complaint by itself puts him in a protected class, whether it is a frivolous complaint or not. By the language that was just read,
that's true.
it doesn't. So, and there would be a problem with most individuals who owned a business that this person can go file a complaint and probably also be a slacker, or maybe come to work, not come to work like they're supposed to, but because by that language, they have filed a complaint, they are now considered a protected class. And I think that may cause some consternation amongst my members, knowing that we're creating a protected class of just people who filed a complaint, not founded or not while the process is going on, but even after, if it was found to be that complaint was to be false, that it was done in bad faith, that by that language, they would still be protected and that employer could not fire them lest they face additional challenges from your body because they had made a complaint in the past, regardless of how true it may not have been.
Well, I think the issue is that as a basic matter, what this bill says is that employers can't fire or take adverse action against someone for filing a complaint, period. If you take adverse action against someone for being a slacker or for not being a good employee, that's a separate issue. But just like under our civil rights laws, there are protected classes. And here, again, these are rights that the General Assembly has created. They are labor standards that we want to be enforced. In order to enforce them, we have to provide some protection for people who stand up, speak out, and make a complaint. It may be that that complaint is found not to have merit, but regardless of whether it is ultimately found to have merit, the act of complaining is what this bill seeks to protect. And that is correct.
So again, it sounds like you're trying to create an additional protected class of people outside of, as you were saying, the Civil Rights Act, that merely by complaining, you now should not be able to be terminated. Even if it's slander, even if it's libel, even if you've lied, even if you've perjured yourself, that under these circumstances, you should not be able to be terminated for lying or putting out a false narrative against your employer.
Well, I think that's a separate question. I mean, could an employer sue an employee for slander?
As long as he doesn't fire them.
Well, it's an adverse action, right? So the point is the act of complaint doesn't by itself is a protected activity. I think everyone in this body would agree that it is a protected activity and should be a protected activity. Because again, we want people to step forward and say if they are see child labor happening, we want someone to be able to step forward and say that without fear of being fired for doing so. But sir, it's the connection between the employer's action and the complaint that's the issue. You can fire someone for being a slacker,
right,
assuming no, but you can't fire them for simply making a complaint.
We all understand that, but if I say that Pippi is hiring, a bunch of 8-year-olds to do his bidding at his law firm, and I put that out on the internet and I file that complaint under this language, although it's farcical and far-fetched, I cannot, he still has to employ me. He can sue me, I guess, which is odd, because it's an adversarial relationship, but he still has to employ me, even though that it's been proven that because I understand the active complaint. I think everybody in this room does. That while a complaint is active, while it's moving forward, while investigation is going on, nobody should be terminated. But if the findings that are that it was done in bad faith and that there's an actual lie by what he was reading, they cannot be fired for lying and making these things up and forcing their attorney or their employer from spending could be large amounts of money in defending a lie.
Yeah, I think this bill, I think maybe the clearest answer is this bill doesn't speak to whether the employer has that right or not. What it says is that the act of complaining and the act of engaging in any of the protected activities here, that should be protected against retaliation.
Right.
It doesn't speak to the issue that you're describing. That's true.
I'm just, because it actually does speak to it. And I think that's his point. It says that you still can't fire them. It does speak to it very specifically, because it doesn't say once a complaint was found to be true or
Unfounded.
unfounded. It just says made a complaint. So I think that's an issue that I myself have heard, but I think that's an issue we'll have to stumble through. I was just trying to get your understanding, and I appreciate your forthcoming nature on this one.
Okay,
I
thank
see
you.
we have a few questions. I'm assuming they're going to be short. Delegate Adams. Wait, I'm sorry. Wait, I got to do this only because you've been talking all day. Go ahead, Seth. Because he never talks. Oh, I'm sorry.
Maybe they're short. I don't know. No, just I wanted to call, the very salient points from the chair, and I just wanted to talk quickly and ask you quickly what the 100,000-foot view of that process is and how long that takes.
So I think it has, the process is that someone comes to the commissioner and files a complaint with our, employment or wage programs. That complaint is then processed. There's potentially interviews if necessary, again, if it meets the thresholds of protected activity and adverse action. Then there would be an investigation and there would be a merits determination made. That's all supposed to happen quite quickly under the language that we've written, both to make sure that an employer is not under investigation for an undue period of time, and also that to the extent that there has been a violation, that recourse.
Historically, what is that undue period of?
I believe we have 90 days is what it says. Within 90 days after the receipt of a written complaint, commissioner shall conduct an investigation.
Conduct an investigation, but it doesn't talk about completion. What's the completion?
If you're asking me what is the average time that it takes to complete?
Exactly.
Okay, all right, sorry. The short answer is that we get very few retaliation complaints because the laws, as noted, have different procedures, and our wage programs really get very few. It can take some time in order to be able to interview and thoroughly investigate and make sure that we have the information we need to make the merits determination. But I can't sit here and tell you what an average is. I think it's a very small universe.
Whatever period of time that is, we're not sure. That person would be, like was stated here, protected. Okay, thank you.
Thank you, Mr. Chairman. And Commissioner, so this is my 10th year in office, and I would love offline, because I think I'm not going to be given the amount of time to ask the kind of questions that would help me work with the department on bills like this. But let me just say I'm offering that up, and I'll make sure I send the contact information through.
I appreciate that very much.
My history in the legislature starts with a fight with Maryland's Department of Labor and the commissioner at the time. So I have insight because I'm a fair actor in the business marketplace. And I also am aware of how the department, when you have rules that aren't clear with clear paths to compliance, it creates confusion, which can lead to very bad outcomes, is my testimony. So the question that with that preface is that the bill apparently doesn't repeal the existing anti-retaliation provisions. So they mention in here that it may create confusion. And the problem I have with that point is that elsewhere in this fiscal note, your department has determined that this bill has little or no impact on the small business. And I would press and say that I think it has a significant effect on the small business, because we're creating confusion where there is more simplicity. For example, and I'll get to the question, under wage and hour law, if there's a wage and hour complaint and it's made, there's already in statute the ability to deal with that from your department standpoint, and also protect the employee who makes a claim. What you're doing in the bill is you're trying to take perhaps 2 new additional places where you don't have anti-retaliation, add that, but you're actually trying to create this umbrella of enforcement and or protection mechanisms, but you're not getting rid of the other places where this exists. That's confusing. Would you agree?
So thank you for that. Yes, we are attempting to create an umbrella. That's I think we've been very straightforward about that. I would say, though, that under the wage and hour law, the example that you provided, I believe that the only protection for retaliation under the wage and hour law is a criminal misdemeanor prosecution.
Only.
Yes.
A criminal, I would not deem that to be only, but go ahead.
Well, I think as a practical matter, state's attorneys are not bringing these cases. I do not know that people know that they can report it to the state's attorney. I will tell you, our Employment Standards Service, at least in the time that I've been there, which has not been long, we have never received a complaint of retaliation. We have no methodology for processing that complaint of retaliation under our wage and hour law. And that is, so that kind of protection. And I would also add that most of the complaints that we do get about failure to pay wages, failure to pay overtime properly, are brought by people after they have separated from service. And I would suggest to this body that one of the reasons for that is because people do not feel like comfortable filing a complaint or raising an issue with respect to whether they are getting the proper wage and whether they are being paid correct overtime and other compliance issues with our wage and hour laws until after they have already left employment. And that speaks, at least to me as a regulator, that there may be a problem there in terms of the level of protection that we are providing.
Well, as a regulator, it seems like that's a different bill because all I'm asking is for simplicity, and the bill is not providing simplicity or an umbrella. It's providing an additional layer of complexity.
Well, we would disagree with that.
Well, I'm sure, but I am telling you as a business owner, when I see this, and maybe I'm above average as far as a small business that looks at how this stuff affects me. It's my one trick pony here in Annapolis, and you and I just can't simply agree to disagree on this. I think that this is a fundamental problem on anything that you're going to bring. If there is not a clear, bright line path to compliance with what it is you're trying to do, then why bring it? Because if you wanted to pass the bill and say, we're going to take anti-retaliation and we're going to consolidate it and we're going to make it easier for the department to enforce, you have to, by definition, take it out of the individual statutes where it exists so employers understand what's going on. That's all.
Well, I think our thought, and again, this is why we should have a further dialogue. I would welcome that. I think
Yeah, absolutely.
Yeah, I think our thought was this does consolidate it, and we did not wish to disturb, right, the original judgments that to the extent there are anti-retaliation processes and remedies, provisions that already existed in the law. We thought that that would be best to leave it intact, partly because employers are, to the extent that people avail themselves of those remedies, employers are more used to that, and this General Assembly has already made that judgment.
Delegate Charkoudian.
Thank you, Mr. Chair. Welcome to the Economic Matters Committee, Commissioner. It's good to see
Good
you
afternoon,
here.
Delegate.
And I also want to thank you in the short time that you've been in that position. I think you've taken on some really challenging issues. So I want to thank you for taking all of them on, including heat stress and including this issue. I do know I've had some bills over the last couple of years that are related to some of these issues that are in front of us, and some of the and adding enforcement mechanisms, because I'm aware of the challenge of enforcing these. And consistently, what I've heard from my colleagues is that we ought to have an agency that's doing the enforcement. And I feel like this is what you've responded, as opposed to adding additional private right of action and otherwise. And so I feel like that's really what you've stepped up and tried to create with this. And I suspect you'll continue to work with us on adjusting things, but I think it would be helpful. And I know you did this a little bit in your initial testimony, but I think it would be helpful just to go back and talk about the reality of what each of these areas are and like what's happening for people. So like what misclassification actually means in terms of the employee and how they lose, and what misclassification means in terms of the state and how we lose. If you could just give a couple of examples of the bigger picture problem that this is solving, because the reality is when we are not enforcing these laws, that has huge implications for individuals and for the state. And I think all due respect to maybe there's some adjustments in there, I just want to make sure we're fully committed to addressing these big picture issues that are in front of us right now.
I appreciate that opportunity, Delegate. I'll start with the simplest one, which is the minimum wage law that this body passed just last year to raise the minimum wage. If people are not receiving the minimum wage, again, and they complain to us about it, under current law, there is no complaint that they can make to my office or to any agency of the state government other than the state or county prosecutor about that. That is a problem. The point of raising the minimum wage was to lift people up. And to the extent that people are not getting what they are entitled to under the law, and they're not getting it, or they are being fired or adversely impacted by raising those issues with their employer, that undercuts what this assembly did with the minimum wage. Similarly, with worker misclassification or workplace fraud, as it is also known, this is a practice that is prevalent and present in the construction industry. It is present, I'm sorry to say, even in state-funded construction projects. This is the state's money that is going to contractors, and there are some contractors who are paying people under the table and who are not taking out or remitting taxes to the state. They are not covering people doing dangerous work with workers' compensation. They are not providing healthcare. Those are all consequences of misclassifying persons who are employees as either independent contractors or simply choosing not to classify them at all, and paying them off the books. Those are practices that the workplace fraud law, which is subtitle 9 of the labor employment article, seeks to try to address, particularly in the construction industry, but also in the landscaping industry. We have to know about these problems in order to be able to try to solve them. And particularly for low-wage workers, particularly for immigrant workers, vulnerable workers, these are the people who are least likely to speak up and who may be most affected and most vulnerable to retaliation. And that is one of the reasons why we felt a bill like this, and again, we are happy to work with members of the committee to refine it and to make it better. But that is one of the reasons why we felt it was important in order to actually make the standards that this body passed mean what they say. People have to be able to feel comfortable telling us about the problems. And we have to be empowered to do something about it if they are sanctioned for coming to the state with a problem in the first place.
Mr. Chairman, just a couple of questions. So to follow up on what Delegate Pippi was asking, starting on page 3 on to page 4, it talks about the commissioner may issue a civil penalty up to $1,000 per infraction against the employer. If an employee prevails, entitled to 3 times lost wages, punitive damage, counsel fees, injunctive relief, any other relief. So if the case is adjudicated and it's found for the employer, why wouldn't the employer have those same rights, or do they? I'm not an attorney, so do they have the right to recover for costs? And I imagine it gets rather expensive to defend a case like this. So if they're found innocent of those charges, is there a section in here where the employer also has the right to recover those same counsel fees?
No, there is not. It does not have an opposite fee shifting provision. I will say, and that's a good question, Delegate Wivel. What we did here, again, in an attempt to not reinvent the wheel, was adopt the process for processing, receiving, resolving complaints that was adopted by the General Assembly in connection with the family program. That's what we looked to because that was the most recent law that addressed it. And we literally just simply imported those provisions. So those provisions that you're describing were not present.
Do you think it would be reasonable that an employer would have the right to recover those costs?
No, I do not. And not in every single case. In a case where we do have some statutes which provide for sanctions against employees who make frivolous reports and put an employer through an unwarranted, baseless investigation. We do have some statutes like that. But simply for failing to be able to prove a case in court, to have attorney's fees be assessed against an individual, that would be very unusual, sir. And as a practical matter, again, the reason why attorney's fees and damages and injunctive relief are part of what a court may, not shall, but may order in a case like this is because retaliation is a very serious violation. Because if an employer takes action again against somebody who has complained simply for the act of complaining, simply for the act of exercising their rights, we can expect that those rights will not be exercised as frequently or as robustly as they could be. And that is why retaliation under many statutes has that fee shifting provision. I'm sorry, I know I went on a little long. I hope I answered your question.
Yeah, I think so. One other question. Can these complaints be made anonymously, or does the employee always have to identify themselves?
Under some of our statutes, this law doesn't speak to that one way or another. But as a general matter, in some cases, the General Assembly has made a judgment that complaints should be anonymous, and in others, it is silent on it. This bill is silent on whether it is anonymous or not.
So what do you all do with anonymous complaints?
In the retaliation context, we haven't really had one, at least not
Well,
since
if
I've
it's
been.
anonymous, obviously there couldn't be retaliatory because you don't know who it is, but if you receive an anonymous complaint now, do you act on it?
As in, we do not know who the person is.
Correct. You don't.
It depends on the context. It depends on the context.
Okay, thank you.
We certainly could not get relief for someone who remained anonymous.
Thank you, Mr. Chair, and welcome. I also want to welcome you to ECM as a new commissioner.
Thank you.
Thank you for your work. Since I assume these bills might come to my subcommittee, I can't help myself but asking. In the course of formulating the legislative ideas, such as this package of bills, what kind of input do you get from the business community? For example, do you work with the chambers and industries to be regulated to figure out what's the practical way forward?
The short answer is on this bill, I believe, and again, forgive me because I am new to this process. I have not directly had conversations, but I believe our department has had conversations with both the chamber and other business groups about this bill.
And they're okay with that?
Are they okay with it? I actually, since I have not had those direct conversations, I have not received any input. I would suspect that there is dissatisfaction with aspects of the bill, which I suspect we'll hear about.
Thank you.
Thank you, Mr. Chairman. Thank you for coming in and bringing this forward. I just want to get some clarifying statements for my notes. So what I'm understanding is that you're trying to have a consolidated bill that's addressing anti-retaliation, especially in areas where we don't speak to it. Right? That's the general gist of the bill.
Correct.
And so when you provided some of the remedies, or for the process at least, are we taking it from existing language we have other places, or we have added pieces in there? Because that's why I'm wondering, specifically for some of the language that was issues that were listed about making a complaint. Do we have this sort of language in other statute that talks to this, or is this new?
This was language. Thank you for that question, Delegate. This language specifically was taken from the family bill.
So we have seen this before.
We've seen it, and this body has adopted it.
Okay.
And that is the reason that we pointed to it in our bill.
Right. So
Yes.
somehow or another, we passed this before and thought we understood what that meant when
Yes.
somebody made a complaint.
Yes.
Okay, is there any other language in here with regards to remedies, the process of 90 days or the fines that's new?
I believe it is similar to, it may be even identical to the Healthy Working Families Act, which was a predecessor bill for the Family Act.
Which we adopted before.
Correct.
Okay, if you find something that's new, would you let us know?
Yes,
Thank you.
certainly will. Thank you.
I believe that's all the questions we have. We'll move on to our panel of unfavorables. Mike O'Halloran, Tommy Thompson, and Sarah Price.
Thank you.
And good afternoon, Mr. Chair, Mr. Vice Chair, and distinguished members of the committee. Thomas Thompson on behalf of the Associated Builders and Contractors, in respectful opposition to the construction of this bill. There was supposed to be an amendment to actually add a provision of the law that was forgotten, the wage payment and collection law. So I'm going to speak to them all broadly. What you're looking at is a bill that has 6, arguably 7 different pieces of the labor and employment or the state finance and procurement article. That's if you take the workplace fraud statute and look at it in its bifurcated way, where you have a misclassification, which is a mistake, and you have a knowing violation, which is purposeful. It's worth noting that 7 of the 5 statutes have retaliation provisions. They have provisions on how it's reviewed, how you adjudicate it, and what the penalties are should you be convicted of those violations. Concerning is that those 5 retaliation provisions are not touched by this bill whatsoever. They're not taken out of the law with this standalone provision, and they're simply left there to kind of run parallel to the process. That's going to be a problem for litigants. It's going to be a problem for attorneys. It's going to be a problem for judges and juries when they have to figure out what path are we taking with these violations. We need to think about that in actual practice because that drives litigation costs. It would also be persuasive if the department actually came in here and said, hey, look, we have 5 statutes with retaliation provisions, and we're seeing employees come forward because they know there's a safety net, that they won't be fired because they can speak out against their employer. And yet you heard the opposite. That's not occurring whatsoever. Would have been more prudent if we had looked at the 2 laws, and that's the living wage and the wage and collection law, and said, we need retaliation provisions in them. And we looked at those laws specifically and found a way to actually weave them into that portion of the law. And if I can last speak to the damages in this case, there are treble damages, which are punitive damages. You have to think of them that way. They're simply capped. And there are punitive damages on top of that, completely unfettered. I don't think I've seen a statute passed down here that has double punitive damages in it. I don't know how you work that in court. With that,
Good afternoon, Mr. Chairman, members of the House Economic Matters Committee. For the record, Mike O'Halloran here today representing NFIB. I share a lot of the comments that my colleague, Mr. Thompson, just made. You know, if you look at the fiscal note and even by the commissioner's own testimony, there are anti-retaliatory language in these various areas of law already. So the questions remain, so what's changed? Why is this bill necessary? Has there been a discernible uptick in the amount of complaints, whether they be criminal or civil or what have you? And the response from the department when I asked that, and again in the commissioner's testimony, is that there have not been. And the department would further have you believe that if this bill were in place, then those complaints would come forward. My response to that is it's already in law. There are already anti-retaliatory processes in law, whether they are through, you know, as we've talked about the family law, for instance, even in the current statute, there are departmental processes, complaint-driven processes to go through that, in addition to, you know, private relief. So it's, you know, the commissioner is right. I mean, there are already, to use her words, very robust laws in place to protect our employees and workers from bad actors. And at NFIB, we encourage that. We do not want to see bad actors because they ruin it for the many NFIB members, including some of the business owners sitting around this dais who are doing the right thing. But the idea that this is, you know, this is in an effort to standardize a practice, you know, from an employer's perspective, asking their Department of Labor, because again, the Department of Labor also represents employers. You know, when we're talking about standardization, we want to see standardization when it comes to regulatory requirements, when it comes to cross-agency filing. Those are the sorts of standardization that we as employers are looking for. I mean, heck, we had the department in here last week talking about the family medical leave insurance and some of the updates. The vice chair pointed out, very astutely, like one of the issues that employers are looking for when it comes to standardization is, can we just have a single account number? So these are, again, you'll hear this theme from me throughout the session, but with that, I wrap up and respectfully request unfavorable report.
Good afternoon, Mr. Chair and honorable members of the committee. My name is Sarah Price, and I'm here on behalf of the Maryland Retailers Alliance. At this point, not to be repetitive, I would largely echo the concerns that have already been expressed and those that have already been discussed by the committee regarding additional protected classes of employees. I would ask the committee, if you do choose to move forward with this legislation, we would urge you to consider removing the private right of action that is included on behalf of the employees. We believe that this is unnecessary, as at that point, the state has already gone through a very lengthy process, including action against an employee or employer, excuse me. So we would ask that you consider that on behalf of the business community. So overall, we would urge unfavorable. Thank you.
Delegate Adams.
Thank you, Mr. Chair. So to the panel, I mean, the first question I have is, the Department of Labor is a strong, would it be your opinion that that is a very strong regulatory body?
That would certainly be the opinion of, I think, many of NFIB members. I would agree.
Certainly our members feel that way.
Right. And so the follow-up question to that is, when you see this bill, the fiscal note says that this bill aims to standardize and or strengthen existing anti-retaliation provisions and enforcement. And my question is, you wouldn't be against the idea of standardizing, would you? I mean, for the sake of simplicity and compliance and related things, but would you agree with that?
I don't think anyone's up here testifying against standardization or retaliation. I think it's the construction of this bill and the parallel tracks you're creating and no safety net for employers that is problematic. See, we see in other anti-retaliation laws, and it was brought up, I forget by whom, that, you know, if it's non-meritorious, if it's false, there's a cause of action that the employer can take, because the cost of litigation in this arena is expensive. And the employer can actually ask for attorney's fees as well as a $1,000 penalty in some of the anti-retaliation statutes against employees that make false statements. To Mr. O'Halloran's point, I think we're up here saying, hey, the department represents both sides of this issue. Their mission statement says as such, because if there wasn't employers, there wouldn't be employees. And so we're just asking that if you're going to do this, do it the right way. Take the holistic look at all 7 of these statutes, and really 6, but 6 of these statutes, figure out how you came to the conclusion of this body to make the anti-retaliation provisions work in each one of those statutes, and then fill it into the other 2 that's missing. This umbrella approach is just painting every retaliation with a very broad brush, and it's just not as simple as that.
So, Mr. Chairman, last question, and that is, so what we're left with is, since we're not standardizing under this bill, I mean, I think anyone in the committee is going to look at this and say, this is not a cleanup bill, or this is not a way to, you know, fix a thing that we believe is happening. It's a problem. We're not fixing anything. The question is, does it actually strengthen anything? I mean, does it actually achieve anything through the lens of the relationship between a very strong regulatory body and the private sector? And I don't see any virtue in the bill. Maybe you would agree or disagree, but I'm not seeing it.
I think the virtue in the bill is the meritorious approach that the department is trying to take with retaliation. The way they're going about it actually minimizes that approach, because it's so heavy-handed. It's so punitive at this point. It's just not going to create a harmonious relationship in the employment arena, because it's basically saying all employers act in this certain way, when that's certainly not the case. You can see that by the number of filings.
Thank you.
Mike, you mentioned something about the Department of Labor works for both the employers and the employees. Can you tell me anywhere in this bill you see that they've worked for the employer?
With respect, I mean, I'd echo the comments that Mr. Thompson made. You know, look, I think the department is certainly coming from a good place in that it is trying to protect employees. Unfortunately, from an employer perspective, to answer your question, it would seem very punitive, very heavy-handed. And if I'm an employer and I look no further than the fiscal note, despite the fact that, again, not trying to defend the bad actors, but even if I'm a good actor, your colleague sitting next to you can certainly attest to this. You know, depending on the department and who's in charge, you know, these things aren't levied equally. So would I see this as complementary to employees and employers equally? No, I would not.
Thank you, Mr. Chair.
Delegate Queen.
Thank you, Mr. Chairman. So thank you all for coming in, and I do understand an employer's perspective, and we are friends of employers as well. So don't think that. And I'm sure the Department of Labor is too. This is just one of their bills. But when we talk about consolidation or trying to standardize anti-retaliation laws, is it your approach that there's not a one size fit all and we should just have them in the different statutes based on the different types that we have? So those 6 areas that we talked about, they should have their own because they're slightly different and should be addressed differently. Is that the overall approach you all are taking? Is that what I'm hearing?
So I think you could actually do it both one of 2 ways.
Okay.
You can take the approach, and the legislature has done that approach in 5 of these statutes where they have anti-retaliation laws. They tailored it to that provision of the statute.
Okay.
We have 2 left. And so now we're trying to figure out how to bring those 2 under this new umbrella. So you can either have a totally new statute on retaliation that covers all 5 of these, abandoning the old method.
Correct.
Or you can tailor it to the laws. You can't do both. And that's where the confusion comes in. And if you look at the bill as it's drafted, there's 2 civil causes of action. I've never seen that before, where
Gotcha.
the department or the attorney general can bring an action, and then the employee can bring an action. It's just the way this is drafted is currently unworkable. I mean, business would love an opportunity to work with the department on this. Again, the meritorious reason for this is we support as well. It's just how we're going about it and how we're getting to the end result that we have a lot of problems.
Okay, so you wouldn't be opposed to either working with the administration on covering the 2 that aren't there, or strengthening the other 5 so that all seems sort of standard in the approach that we're taking for our process and punitive actions, if any.
Absolutely.
Yeah, I think so. And you know, the word standardization has been brought up a lot. You know, I would agree that yes, what's in this bill creates a standard. But the problem is that it doesn't standardize the effect of anti-retaliatory laws throughout. What it does in actuality is just pile on top. I hope that makes sense. It doesn't mind.
No.
In my simple mind, at least, which probably isn't
No,
set.
mine is even simpler when it comes to the legal matters. So, okay, no, I get that. I'm just trying to figure out how do we get to something that's workable. Thank you.
Well, seeing no more questions, I would like to remind everyone listening, as well as those who presented, that the good thing is that's what we have subcommittees for. And I always say this, I appreciate everybody working together, but that's not how we do it here. It's our job to make that decision. We love a hearing from you, but
Yes,
it's
sir.
ultimately our job. I don't send adversarial parties out to bring me something back that everybody can. That's not my job. My job is to make good policy. Some people want it all, some people want none, but our job is to make good policy. So I appreciate you working with each other, but I ask that you work with my subcommittee chair and my subcommittees, because that's where the decisions are going to be made. We're not trying to find a middle ground. We're trying to do the right thing.
Yes,
So other than that, I think this concludes our hearings for today. Colleagues, be aware that we do have an event tonight at 6. I would love to see as many people as I can there. Make sure when you park your cars, you do so in a safe area so they don't get stolen. Thank you and look forward to seeing you.